What is a living trust? Attorney Steven Spewak says, the term living trust is used to describe a trust created by a person during his or her lifetime. Lawyers will often refer to a living trust as an inter vivos trust, using the Latin phrase for this type of trust. The most common type of living trust is a revocable trust, and in everyday parlance, this is the type of trust people refer to with the term living trust. A living trust is used to substitute for a will, in that when a person has a living trust, it is the living trust that says where the person's property goes after his or her death, rather than his or her will. Any provisions that a person could make in his or her will as to whom he or she wants his or her property to go at death and how it should go can instead be included in a living trust. A living trust is created by a written document in which the person creating the trust spells out the trust's terms, and by that person then transferring ownership of his or her assets to the living trust. That might include transferring ownership of your home, bank and other financial accounts, and the like to the trust. The primary reason people use a living trust as opposed to a traditional will, and the reason for its widespread popularity today, is to avoid probate. That is, if assets are held in a living trust, as opposed to being owned in the individual name of the person who creates the trust, those assets avoid probate when the person dies. Another purpose of a living trust is to make the management of a person's property and the support of him or her and his or her family as efficient and seamless as possible if the person at any time becomes mentally incapacitated. For a free phone consultation, contact Attorney Steven Spewak in St. Louis, Missouri at 314-492-6611 or visit him on the web at www.estateplanmo.com.